Welcome back, future criminologists. In this video, we will be discussing the crime of delay in the delivery of detained persons to the proper judicial authorities. Delay in the delivery of detained persons to the proper judicial authorities. Delay in the delivery of detained persons to the proper judicial authorities is a crime governed by Article 125 of the Revised Penal Code. From Article 125, the following are the elements of the crime: delay in the delivery of detained persons to the proper judicial authorities. First, offender is a public officer or employee. Second, he has detained a person for some legal ground. Third, he fails to deliver such person to the proper judicial authorities within 12 hours for crimes or offenses punishable by light penalties or their equivalent, 18 hours for crimes or offenses punishable by correctional penalties or their equivalent, 36 hours for crimes or offenses punishable by afflictive penalties or their equivalent. Now let us discuss each of the elements of the crime. First element, offender is a public officer or employee. The officers liable are those with power to actually detain or to cause the detention of a suspect of a crime. This crime penalizes a public officer other than a judicial officer. For example, policemen. Hindi po kasama ang judges and justices po dito. Second element, the public officer has detained a person for some legal grounds. Article 125 contemplates a situation where arrest was made without a warrant, but there exists a legal ground for the arrest. Dapat yung arrest dito is within the instances of valid warrantless arrest. Ano nga ulit yung mga instances of valid warrantless arrest? Una, in flagrante delicto arrest. Pangalawa, hot pursuit arrest. And pangatlo, arrest of an escapee. Ang mga topic na ito ay na-discuss na po namin. Check the link of the videos on the description box. Article 125 of the Revised Penal Code does not apply when the arrest is on the strength of a warrant of arrest, because in the latter case, a person arrested can be detained indefinitely. Hindi na po mag-a-apply ang Article 125 pag may warrant of arrest. Pag may warrant of arrest na po kasi, may kaso na rin po yan sa court. Take note, the meaning of detained or detention here is the same with our discussion in arbitrary detention. What if there is no legal ground? If there is no legal ground, then the crime committed is no longer delay in the delivery of detained persons to the proper judicial authorities, but arbitrary detention. You can check again the discussion of arbitrary detention in our previous video. Third element, the public officer or employee fails to deliver such person to the proper judicial authorities. Let us define first what we mean by deliver or delivery. Delivery means the filing of correct information or complaint with the proper judicial authorities. It does not mean physical delivery or turnover of arrested person to the court. Hindi ito yung pagdala sa offender sa court. Hindi po yun ang ibig sabihin ng delivery. Ang delivery ay pag-file ng information or complaint sa korte. Dapat yung information or complaint na rin yun ay correct, kasi pag void po yung information or complaint, it is as if hindi po na-deliver yung arrested person to the court. In this crime, it is not the arrest which brings about the crime because the arrest is valid, but it is the subsequent inaction of the arresting officer which is the essence of this crime. Dito po ang arrest ay valid. Nagiging liable ka lang under Article 125 dahil sa hindi mo nagawa matapos mo siyang arestuhin. Next, sino or ano naman itong mga proper judicial authorities? The words judicial authority as contemplated by Article 125 mean the courts or justices or judges of said courts vested with judicial power to order the temporary detention or confinement of a person charged with having committed a public offense, that is, the Supreme Court and other such inferior courts as may be established by law. Judges or justices ang tinutukoy dito. Prosecutors or fiscal ay hindi sila kasama kasi they are not under judiciary at wala silang power to order the temporary detention of a person. Next, when is detention become arbitrary? Or kailan may delay? Kapag delayed na, then it is considered arbitrary. The detention becomes arbitrary when the period of detention exceeds 12, 18, or 36 hours as the case may be, depending on whether the crime is punished by light, correctional, or afflictive penalty or their equivalent. How to count the hours? According to the notes of Prosecutor 𝐂𝐵𝐷𝐲𝐸, we count the hours continuously and without interruption from the time of arrest. But if the last hour falls on a non-working hour or non-office hour, the charges should be filed within the next office hour. The Supreme Court in the case of Soria versus Desierto, reiterating the case of Medina versus Orozco, held that the hours of non-office days is not to be included in the counting. Let's say nahuli ka ng Thursday and Friday naman ay holiday. Pag magbibilang ka, hindi mo isasama ang Friday, Saturday, and Sunday. Saturday and Sunday being non-office days. In our discussion of preliminary investigation and inquest proceeding, we said that when an offender was arrested in flagrante delicto or in hot pursuit, hindi po preliminary investigation ang mangyayari kundi inquest proceedings. What if itong offender na ito gusto niyang i-invoke yung right niya to have a preliminary investigation? Ano pong gagawin niya? Under the revised rules of court, the offender should waive in writing his rights under Article 125. Waiver must be under oath and with the assistance of counsel. Kailangang i-waive kasi mas madaming oras ang kailangan sa preliminary investigation. Pag nag-waive siya, hindi na po mag-a-apply yung 12, 18, or 36 hours as the case may be. What if the person arrested does not want to waive his rights under Article 125? The arresting officer will have to comply with Article 125 and file the case immediately in court without preliminary investigation. Paano pag ayaw niyang i-waive? Yung arresting officer ngayon must comply with the 12, 18, or 36 hours. What is the effect if the information was filed beyond the specified period? The filing of the information in court beyond the specified period does not cure illegality of detention. Hence, detaining officer is still liable for under Article 125. Neither does it affect the legality of the confinement under process issued by the court. Pag nag-exceed ka na sa 12, 18, or 36 hours, mag-file ka man o hindi, liable ka na under Article 125. Pag nag-file ka beyond the period, hindi na po niya makukure yung delay mo. Liable ka na under Article 125. Sabi natin kanina, in this crime, the arrest is valid. Kahit delayed po sa pagpa-file ng kaso, hindi po maaapektuhan ang legality ng arrest. Thank you for watching. If you like this video, don't forget to share it and to subscribe.